A candidate who was showered with praises for her lucid judgments during her acting stint at the Gauteng High Court division sparked a debate on the relationship between private property and the Constitution. Academic Professor Wilhelmina du Plessis, who boasts a rich experience within academia and education, focusing predominantly on issues of property law under the constitutional scheme, was probed on the relationship between property law and the Constitution. JSC Commissioner Advocate Tembeka Ngcukaitobi SC probed Professor du Plessis on whether or not she doubts if the Constitution actually embraces an unbridled form of property and whether we can expect a challenge of the notion itself from her, to which Professor du Plessis responded like this.
I understand when people criticize the Constitution by saying, well, Section 25(1) says that the state cannot interfere in, nobody may be deprived of property unless, arbitrarily deprived of property unless in terms of a law of general application. And in that sense, it might be interpreted that it does solidify private property. So I think that answers that question. But I think what is more important is if we think about property in terms of the Constitution, and that's certainly something that I have written about academically. I've recently also written in an eviction case about that idea that property can only mean ownership, and that ownership can only mean ownership to the exclusion of everyone else. That is what we are challenged to interrogate under the Constitution.